Hello, how are you doing? Hope you are doing great. Welcome to Lawyers Infohub. It's always a pleasure to have you on this platform. I thank you, my returning subscribers, for stopping by to check what is new on the channel. Thank you for those who uh, are yet to subscribe, but you also love the channel. So I will encourage you to subscribe. So today, for the love I have for law students, I'm going to drop this video and also for young lawyers. You see, the topic we're treating today is crucial, fundamental, pivotal to the essence of law practice or even being a lawyer. Because you see that most at times, what we're going to learn today is central to a lot of things. It's central to a lot of things in practice, in theory, in so many ways. You see people asking you, please let me look at this document, look at this contract, is it valid? This one, a lot of even legal advice you give on most transactions. You first look at, can I see the contract? Can I see the agreement? Can I see, this is the fulcrum of so many things in law practice. So I'm just happy that I'm going to touch it today. Now, this particular topic is taught under contract, law of contracts in the university. It also comes up again in a letter, maybe the business law class, commercial law class, depending on what the structure is in your place of study. So we're looking at the elements of a valid contract. The elements of a valid contract. What makes a contract valid? What makes a contract valid? Now, let's look at first what is a contract. It's very important. A contract is an agreement which is legally binding. Yes, it's usually between two people, two or more persons. Yes, and it will be such that it should be enforceable in law. You you must also understand the word offer, offeror, offeree. Offeror is the offer that was made, an offer that was made by one party. Now, when the offer is accepted by the other party, you call the other party offeree. Offeree. So you have the word offer, offeror, offeree. These are terms you see in contract. Now, basically, they have classification of contracts. We have the formal contract, simple contract. We have the bilateral, unilateral contract. We have the express implied contract. That's just foundation. Now, the core of what we want to discuss, the elements of a valid contract. Now, one of the basic things you must understand is that there are these requirements are key, which is starts with the offer. When you talk about contract, someone must have made an offer. The second one, acceptance. Someone other and the other party accepted. Someone made an offer, the other party accepted. It's also possible someone can make an offer and there is no acceptance. So when people look at contract, they look at, was there a valid offer or was there a valid acceptance? That's in a higher scale. So basically, elementarily, there must be an offer, there must be an acceptance, there must be consideration. Now, because when we get to consideration, we'll just talk about it. There must be consideration. There must be an intention to create legal relation. Now, this intention, sometimes you see that there was no intention to create legal relation, and that was makes some contract invalid. Parties may have offered acceptance, but there was no intention, for parties to be held liable. There's no intention to create legal relations. So it's very, 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 very key. Now, offer and acceptance constitute an agreement. Then, for the agreement to be enforceable, it must be backed by consideration, the presence of an intention to create legal relations. This is very key. Offer and acceptance creates an agreement. Now, for that agreement to be enforceable, it has to be backed. It has to be up by consideration and the presence of an intention to create legal contract. Sorry for this glitch in the light. Yeah. So but let us continue. The light will be restored soonest. So when you talk about offer, an offer is more like a proposition. Someone is proposing something to you. It will set out the terms in which the offeror is willing to enter contract with the offeree. I earlier mentioned to you that we have what we call the offeror and the offeree. You know, the offeror, the person offering, and the offeree, someone accepting. So when there is a valid offer, it means that someone has offered or made some proposition, and the other person also understands that proposition in the light of which the person making the offer has made it. So a valid offer must be definite. It must not be vague. It must be definite, unambiguous, and unequivocal. When you're talking about an offer, it has to be definite. So when maybe you're asking an exam to talk about offer, in the shortest way you can state it, that an offer, you know, must be definite, unambiguous, and unequivocal. There should be no room for speculation. Someone should not state, I think this person is stating this. It should be straight. There should not be room for speculation of what you're thinking or what the other person is thinking. So it has to be what definite. So I'm going to just be highlighting the main key features. Peradventure, you're being asked to talk about this. So what are the things you need to look out for? So to constitute an offer, there must be more than an indication of interest in making it. If someone can indicate an interest, I like this, I want to have this, but the person has not made an offer. Now, we have what we call invitation to treat. When you go to the market, sometimes you see some beautiful things. They will say 2,000, 2,000, 2,000. You see some people calling ridiculous prices for very beautiful things. Because of that discounted price they are calling, people are attracted to them. When you now come close, you now see that what they are selling that thing is not what we're calling it. So that's an invitation to treat, something that entices. So it's different from what an offer. So there's a difference between an offer and what an invitation to treat. Just like I told you, an offer must be definite, unequivocal, must be clear. You must know what the person is offering. It's not like a mix-up. You understand? There's also a difference between an offer and auction, price list, catalogs. When you go to some big shops, you see some catalogs of prices on certain things. Sometimes they may not be the real price. When you now go to buy, you see that these are prices to attract people, and it just all maybe a discounted price for a particular period of time, which is not valid for all times of the year or all times of the month. So these are where we have little differences, or you can call it, but there are differences. Now talk about acceptance. To constitute an agreement, an offer must be accepted. Just like I told you, someone has made an offer. Another person must what? Accept what the offeror is what bringing to the table. There must be what? Acceptance. Now, sometimes you see in a contract, they say in an agreement, they say subject to contract. What is that? Its effect is very also key. And acceptance must be absolute and unconditional. Just like an offer must be definite, unequivocal, unambiguous, an acceptance must be what? Absolute and unconditional. It should not be contingent on something. It should not be conditional upon the fulfillment of something. It must be what? Absolute and unconditional. We also have what we call counter offer. So we can make an offer, another person makes a counter offer before an acceptance. So a counter offer should not be taken as an acceptance. Somebody is saying, okay, you're offering, I'm giving me 1,000, I want to give you 500. There is no acceptance yet. It's in the realm of negotiation. So your acceptance must be absolute and what? Unconditional. Now there are ways to communicate what acceptance for it to be what? Effective. It could be in writing or orally. You know. Now also um it must be understood that in this era of technology, it will also be by way of a tech, WhatsApp, emails, all those ones are also, factored into the realm of acceptance. People can use posts, a lot of ways to, you know, communicate to show we accepted what you offer. Now, there are ways to also terminate an offer by revocation. An offer can be revoked. Yes, an offer can be revoked. Now, issue of lapse of time. If, for example, someone has made an offer, say you must accept this offer on or before the expiration of, or on or before the third day of the month of this, and you did not give acceptance, that offer has not lapsed. So, termination of offer can also be by lapse of time. If there's a time upon which that offer should exist or last, and you don't accept it, it has lapsed. When there's death of parties, the offer can also lapse. Issue of rejection. Rejection can come in form of a counter offer, what I told you earlier. So someone can do a counter offer and say, well, I'm not accepting this. This is what I'm proposing. So there's a counter offer. Now we look at the third consideration element, which is consideration. Consideration is the third element of the valid contract. So consideration is key because it takes an agreement to another level to become enforceable. Is an essential to the formation of any contract. Now, consideration may be defined as an act of what? Forbearance of one party or promise thereof. It is the price. It is a price for which the person making an offer or promise is bringing to the table for the other. It's for the value of the agreement, the value of the contract. So people look at consideration as also price. What is the value of the thing we're doing? What is in it? That is the price that is pegged to this agreement, pegged to this contract. Now, there are rules that govern consideration. See that consideration may be executory consideration or executed consideration. Now, it's executory where the parties exchange what? Promises. Now, it could be executed when a party has promised you to do something in return for the other party to also do something. Now, consideration need not be adequate, but it has to be what? Sufficient. This is where we now look at the issue of sufficiency of consideration. Sometimes in an exam, a question may be asked that this person made an offer or they are in an agreement and this person offered one cent. And someone is asking, what will 1 cent do? Is 1 cent of value? You see, consideration, it need not be adequate. It may not be in the millions, it may not be in the thousands, in the trillions, but it needs sufficiency. So that is what we call sufficiency of what? Consideration is very, 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 very important. So the sufficiency is what matters. Now, consideration must not be past. Must not be what? Past. Must not be past. You have to note that. It has to move from the promisee to the promisor. Yes. The doctrine of privity of contrast comes in here. So it's very important that this consideration moves from one party to the other. At the end of the day, it's not like he's just resident on one party or he's resident in another person. Now, the intention to create legal relation as a vital element of a valid contract. The law will not necessarily recognize the existence of a contract enforceable in a law court because of the presence of mutual promises. No. That the fact that you promised each other, someone made an offer, another person made an acceptance, does not even give you that flavor. What gives you the flavor of a valid contract is that both parties had an intention that this our agreement creates a legal relationship between us. Yeah, so you could look at issues of a family agreement, maybe enter between husband and wife. Someone would ask, does it create, is it issue of does it have an intention of a legal relations, commercial agreement, and all of that? There are lots of cases under this headings, but I'll just run through it. It's just a tutorial class for you to have an idea of what all this means. Then we have issue of capacity to contract. Who can enter into contract? Can a small baby enter into contract? Issue of minors. What is the capacity of a minor to enter into a contract? The capacity of a minor is what's restricted. So you must know the level to which a minor can enter into a contract. Someone is telling you that he entered into a contract with a 15-year-old or a 16-year-old or a 12-year-old child, you wonder, does that child have what it takes, the capacity to enter into a contract? So these are things. Look at the Child Rights Law or the Child Rights Act. You know, when can a minor be said to have entered into a valid contract? The exceptions. What are the general rules? You know, and a minor enter into a contract involving luxury? Look at it. Valid contracts which are binding on the minor. Executed contracts for necessaries. What are necessary? Necessaries are goods suitable, to the condition in the life of that minor. It's very important. In such executed contracts for necessaries, a minor can enter into a valid contract. Now, we have void contract. Issue of loan. An infant has no capacity to enter into a contract of loan. Contracts for non-necessary goods. Non-necessary goods are goods that are not important to the condition of life of that minor. A minor entering a contract to buy a Rolex watch, buy a very expensive brand. Does it work? No, the void contract. Yeah. So we have to understand, can an illiterate enter into a contract? A person of unsound mind, a bankrupt person, a drunkard, can they enter into what? A contract. Now, there are ways a contract can be made. It may be made by deed. There are contracts which must be in writing. That's what we have seen, that there are formal types of contract we have now, but there are also there are specific contracts that which must be in writing. They are required by statute to be in writing. Contracts of marine insurance, contracts for the sale or disposition of land, it cannot be oral. Employment contracts, these are ones that must be in writing. Yeah, so it's very important that we've looked at this valid element of a valid contract. We looked at offer, we looked at acceptance, we looked at even that acceptance in between offer and acceptance. We also talked about issues of invitation to treat, auction, and all of that. We looked at consideration. We looked at intention to create legal relation. Very, very, very key. So it's important to understand all this. And we talked about that offer and acceptance is what constitutes the contract, the agreement. But for that agreement to be enforceable, we look at the issue of consideration and the presence of an intention to create legal relations. I just hope that you've been able to learn something in today's class on the elements of a valid contract. When you understand and take your time to go through this, in the near future, 10 years down the line, 20 years down the line, anything you see on contract agreement, these things really are the fundamental things to ask yourself. Is this agreement, is this contract valid? Was that a valid offer? Was that a valid acceptance, or was just an counter offer which was taken as an acceptance? So I just hope you'll be able to learn something in this brief class today. Just a rundown on this topic we are looking at, the elements of a valid contract. We also looked at what a contract is. We looked at the forms of a contract or the types of contracts that we have. We also talked about briefly on certain contracts that must be in writing. We looked at each forms of consideration, and we looked at sufficiency of it was not adequacy of consideration, but is sufficiency. That the consideration need not be adequate, but must be sufficient. So friends, if you have any question, you want us to expand on any aspect of this class, just drop it in the comment section. You'll get our attention and we'll respond accordingly. If you're yet to subscribe to the channel, please do hit the subscribe button and share this video for others to learn. Thank you and just stay blessed.